today, Wednesday night, and we have a brand new educator from Madeira Beach, Florida. Trisha Murphy works for which title company?
Nations Title Company.
Nations Title Company in St. Pete, Florida. And she's going to talk to us today about the goods and bads and pitfalls and why you should have title insurance for your property. The 7 problems, what is the title of your talk tonight?
7 common title issues.
7 common title issues.
I thought you had good vision, Mark.
Oh, I didn't even see.
It's on the screen.
Oh yeah, that's what I'm looking at her. What do I look at the screen for? If the screen was blonde, I'd be looking at the screen. Anyway, let's welcome Trisha Murphy. Go ahead, Trisha.
Well, good evening, everybody. Having a day. As I said, my name is Trisha Murphy, and I'm the Director of Business Development with Nations Title Agency. And I'm going to talk to you tonight about the 7 common title issues. They are truly the scariest ways to lose your investment. In most cases, I'm going to provide you with real-world examples of how these issues can affect your property without an owner's title policy. So we'll move forward here in the presentation. There's a pretty picture of me, just tells you who I am again. And the next slide is going to talk to you about who I am and what do I know. Currently, I'm actually a licensed real estate instructor in the state of Indiana and a realtor in the state of Indiana, as I recently just relocated from Indiana. I've closed thousands of transactions in my almost 17 years of experience. I've worked as an abstractor, which is the behind the scenes, doing all of the search work on properties, an escrow agent, which are the people that you see sitting at your closing table, real estate agent, and I also have done title insurance sales and management. I've experienced everything from classic cash transactions, typical refinances to the extreme. I put a little funny on here, but it's a true statement. In one transaction, the borrower tried to bring his girlfriend to the closing table instead of his wife. So I've closed deals from the closing table to the waiting area in the ER and even on the trunk of a car. While each transaction has the same bones, no single transaction is the same. If nobody has any questions right now, let's go ahead and get started. And just so you know, I kind of make my presentations interactive, so I do ask some questions. Feel free to answer those questions along the way. So the first common title problem that we're going to talk about is errors in public records. I am going to read a little bit, and then I am going to give you some real-world examples. Clerical or filing errors can lead to discrepancies on a deed or property survey. This can be anything from unpaid taxes that were not filed properly to failing to add a person to the chain of title. For example, recently had a file where the customer closed on the transaction and only after receiving their $100,000 proceeds check informed us that he had a mortgage on the property. The bank had only mortgaged 1 parcel when indeed there were 2. The realtor only included 1 parcel when the property had 2. Question for all of you is, what would have happened if the customer had not told us that the mortgage should have been paid off? Anybody want to answer?
Well, generally an unknowing third party, you would get possibly into an equitable subrogation issue. If there is a purchase money mortgage that finances real estate for an unknowing third party, they would actually take a lien priority position with that purchase money mortgage. Through equitable subrogation, it depends. There's another principle that gets involved, I guess, with what do they call it?
Well, E&O insurance would be definitely hit hard on that. So.
Yeah, I mean, no, it'd be a nasty mess. Obviously, the lender on that first mortgage is going to sue.
Yeah.
And then you're going to be in a lawsuit. And yes, if you don't have title insurance, which you, yeah.
That realtor is going to get bit in the ass.
Well, it's not the realtor. It's the individual. It could be fraudulent.
Yeah.
So yes, you've got a nasty mess.
Absolutely. Absolutely. And does everybody know that the title company, I actually just did a little training with a commercial agent who's looking at buying some residential properties. Does everybody know that the title company uses the legal description and not like the city or county address?
Yeah. Yeah, because I'm a Florida broker, and that parcel number sometimes doesn't have all the things you need. You got to put the full legal address, not some of the ones you just pull out of the LIPA or whatever you have up in Tampa. There's a full legal address.
There's another legal doctrine, and Larry can speak to this just a little bit. It's called after acquired title. And so the two principles that would come up would be after acquired title and equitable subrogation. And they're both nasty. No buyer or seller wants anything to do with either one of them.
Correct. Yes. So the next one, yeah, absolutely.
Yeah.
Absolutely. The next one that we're going to talk about is hidden liens. This is the second common title issue that can happen if you don't have an owner's policy. So debt incurred by a previous owner may become your financial burden if a creditor places an untimely or unknown lien against the property after you've closed the sale. These liens may include items such as credit card liens, tax liens, bankruptcies, child support judgments, or anything that can be filed in public record against the person or the property. And I have a good example of this as well. Give me just a moment. I have notes over here. Sorry, it scrolled right on through. So title companies, and you all seem very educated, but just to give you a little more education here, title companies search public records and have only what is recorded to rely upon. This doesn't mean that something unrecorded does not create a valid lien. For example, a land contract. Often those are not recorded. The typical effective date of a title commitment is approximately 2 weeks prior to the closing date. This can go farther back depending on the county. If someone records a valid lien in that time between the last search and closing, it can become the new owner's problem. Centennial, and I'm using an example from Indiana because this is something that happened to us often. Centennial was a cell phone company that was purchased by AT&T. They were infamous for placing judgments against individuals who had an outstanding balance of $300 or greater. Depending on your state and homestead laws and whether or not it's your primary residence or an investment property, these can attach to a property and be the new owner's problem. Have any of you been responsible for a lien that was placed against a property that you were unaware of prior to closing?
All the time. But I don't check. Steve always checks. That's why I have him as a partner.
So that's his problem, huh?
No, we have an attorney who does it. But yeah, everybody gets bit. I mean, we buy very quickly. I mean, sure. We look at a property today, buy it at, we look at a property at 7 in the morning, buy it at 10.
Well, we work with one owner searches. So, I mean, it's just part of what you do in our business. So we always run that risk. So.
Can it affect your saleability?
Yes. It has.
Yeah.
We actually did one recently where we had an unreleased developer's lien from the 90s in the property. The property actually been sold twice, with once with an FHA and once with a conventional mortgage in between. And then when we got a hold of it, they found it. They found the unreleased. So took us an extra 60 days to acquire the releases on it.
So how long can liens stay on properties?
Forever.
Do liens fall away?
No.
Trish?
UCC liens and tax liens do.
It depends on what they are. They can stay on for as long as 10 years. They can refile every 10 years.
How many times can they refile? I thought it was only twice.
I believe it's only twice, yes. At least here in this state.
You don't think I know that, huh?
No, I think so.
I've been waiting for 20 years for these things to fall.
Unsecured liens, unless they're refiled, in Tennessee are removed after 10 years.
We just made a beautiful deal with the tax lien. We made an extra $250,000. So.
Wow.
The Franklin
tax liens get bare. So the third common title issue that we encounter is secret heirs. And what those are after the death of a property owner, the estate may be handed down to his or her heirs. The heirs are not always known or found at the time of death. If the house is sold and the secret heir steps up years later, the new owner's property rights may be in jeopardy. And according to an article published in September of 2004 by the American Land Title Association, a nonpartisan national trade association representing the land title and real estate settlement industry, a couple purchased a home from a widow whose husband had died without leaving a will. Soon after the sale, the son of the late owner, by a former marriage, came forward to claim his share of the home, which resulted in an expensive problem for the couple purchasing the property. After an owner's policy protected the couple by paying the claim for the missing heir, and they were able to keep the house. In this example, the homeowners could have lost their home had they not purchased the owner's policy. Most people think they are covered when they see title insurance in their closing statements, not realizing that they may only have a loan policy. Has that happened to any of you?
We've had situations where we've had to go procure affidavits of heirship, and so we've had to actually go out and find people to verify, to be able to acquire title insurance, that these were the only true heirs, and there had not been an affidavit of heirship recorded previously. I've had 3 or 4 situations like that.
We're presently trying to kick out. We're trying to kick out an heir right now out of the house we just bought.
Anytime in the auction,
Everything she has, we got.
we have.
I can tell.
We have non-judicial auctions in Tennessee, which Indiana would have that. Florida, you guys have judicial auctions. But anytime I personally see, I see anything to do with the decedent, I make sure that I get an attorney's blessing on the title search, because it's problems.
It can be very messy, and very expensive.
Is there a statute of limitations on that, time-wise?
I actually don't know the answer to that question. I can find out.
It's going to be a lien priority thing.
Yeah.
So in a race to Tennessee's a race to record state. So basically, if you bought it and you recorded a lien against it, you were fine if you have title insurance. But just like she's saying, this is an error that just shows up.
Right.
Nobody knew the person existed.
Right.
And sometimes the records aren't real clear. So if there had been a divorce and the gentleman owned the property in the previous marriage, he gets divorced, they had a kid, they get married again, and that record is not clear, then you're fine. But if that record was clear and the title searchers missed it, you got a problem.
Say that divorce happens and it's a 15 or 20 year time.
You're learning things, Trish?
It's a race to record state.
Of course.
So if it's never been updated, then that still holds true 15, 20 years prior.
Yeah.
Okay.
Yeah. You can have an ownership interest. It could go back to the 1800s.
Yeah.
I mean, people make those arguments. Absolutely.
Wow. That's wild.
So if there's a tax lien and
The chain of title goes from the first, since they took the land from the Indians,
Right.
ever since they started Western government,
Right.
the chain of title goes back to then,
Right.
to 16 or 1700s.
So if there's a tax lien, and let's say there was other liens against the property, does the tax lien, is that
Usually it's first.
superior?
No. Well, only property tax.
Okay.
Property tax.
Really?
Lien, yes, property tax. Lien.
So if they have
It's the recording date of the lien that makes it inferior or superior.
an IRS tax lien could actually
It's inferior.
be inferior.
It is inferior.
Wow.
It's normally almost always inferior.
Now, how about the new?
Are they still abstract in Tennessee?
I don't know when you say abstracting. I'm not. I know we have things called title abstractors, but that's the people that pull the change of title for the. But I guess it's mostly moved to an electronic system now, right, where the companies control it themselves.
Well, and abstracts end up being like books because they go back. Typically, they're taken from the beginning of time, like of the property, and brought forward. And most people don't do them anymore. So I was wondering if they did them there.
My first answer to that would be, I guess not, but I can go, when I go to like smaller counties, you go to the county courthouses and you actually pull the original records, but there's normally a computer update to all of the transactions that shows you book and page and where to go for everything.
Absolutely.
Pretty much this room right here, all 7 things you have, we did them already. So
I see that.
No, he's reading the 4th one and he's admitting guilt. Yeah.
Oh no, we got a nice forgery. I got forgery of Bancorp South the
Actually,
bank.
yeah, that's funny. Forgery did happen.
Go ahead, go to the forgery. We got a good forgery case for you.
Yeah.
So this is the title issue number 4. Something that can happen without your owner's policy is forgery. And sometimes they slip through the documents or slip through the cracks, and make it to public record. If a home is purchased from someone impersonating the true owner or using falsified documents, new homeowners could end up paying a lot of money for a home that is not legally theirs. Another illustration that ALTA published discusses an issue of fraud and forgery. A fraudulent real estate company searched public records to locate property with out-of-town owners. My assumption it was probably here in Florida, and forged and recorded a deed to a fictitious person. This person then sold the property to an unsuspecting buyer, providing a notarized deed, which was also fictitious. When the real owners discovered what had happened, they immediately initiated legal action against the new owners, claiming title to the same property. Owner's policy protected the buyer by paying all the legal expenses in the claim by the out-of-state owners. You said you've had fraud, so tell me about it.
Which case? Well, how long you been in Florida?
I've only been here about 8 months.
Oh, so you missed all the robo signing back in the day of 4, 5, and 6, where that's why we kept our properties in foreclosed for 6, 7, 8. Or 12 years, as Sam Sky does. But I bought property up here. Yeah, I bought property up here in Nashville, 9 townhouses. That back in the day when everything, the world was going down. The day before the foreclosure, I was leaving Nashville. I was up here. I was living in Fort Myers. And I was leaving the day before court. I didn't feel like going to stay in the court because, you lose anyway, not naturally. I quit claimed all the properties to Bancorp South, to the bank that gave me the loan. Okay. I went down and recorded the deed. I'm very familiar with the recording office. I recorded this. I deeded all 9 properties back to the bank. The next day, of course, court, I wasn't there and I lost the case because they didn't know that I recorded the deed. About 3 weeks later, I get a note from the court that they went to court and I lost, which I already knew that. A week later, I get a letter saying that while they were doing that research, probably did a what you did, they found that I recorded something. So they quit claimed the property back to me. Now, they already went to foreclose, so basically they gave me back the property free and clear, is what my understanding would be.
I was going to say,
a week later, they sent me another letter saying that they took the properties, they quit claimed them from me back to the bank, because they had to do it the proper way. Well, I didn't sign anything on that last day.
We've got the Bancorp South forged his name.
So basically, and I looked, I said, that's not my signature. The bank signed my quit claim back to the bank. Basically, they gave me 9 properties. Now they're worth about $200,000 each. I bought for $35,000 each. They basically gave me the properties, which is after they already took off all the money I owed them, and now they took them back. But that's another story.
Wow.
That's another. When I have a good lawyer one of these days, I'll play around with that. So yeah, forgery was huge in Fort Myers, Florida, with all those properties back in the day. That's why I know I had 30, 40, 50 properties that I just they said I was foreclosing, but they couldn't prove it because they robo-signed all these as if they had the title, but they never had the titles for anything. They lost the titles.
Wow.
So yeah, I'm a big. That's probably my favorite one right there. Yeah.
Basically, he's talking about all the MERS problems that they had when the foreclosure crisis hit, and these big banks were extremely guilty of going back and recreating documentation and going and cramming some of this mess through by essentially forging quote unquote signatures. But I think where I've come across that a couple of times actually is some unscrupulous title companies that are dealing with some large escrow accounts, and you get a bad attorney who starts running his own kind of Ponzi scheme through his title business. We've had a couple of situations in Middle Tennessee, large-scale situations where title companies have been blown up that way, or some attorneys have run several $1 million and through and forged a lot of documentation to kind of make money float around.
Tris, you an attorney? You're not an attorney, are you?
I am not an attorney. I should have been an attorney, but I'm not.
You have one in your office, though?
We don't have one that physically sits here in Florida, but I have one that I work.
Because aren't you supposed to have an attorney, if not in your office, at least in the state?
To the best of my knowledge, here. I mean, we have 3 attorneys on staff, but not that review title.
All right.
Unless you know something I don't know. We do know Georgia for our Georgia project.
I'm not going to say.
Well, then I'll have to check on that.
All right. Go ahead. What's up next?
Unknown easements and encumbrances. So an easement provides legal permission for a non-owner to use your property. If an unknown easement is found, it may affect your right to use the property and surrounding land as you'd like to. Similarly, an unknown encumbrance may give a third-party claim to all or part of your property. This is yet another example of why title insurance is important, and to make sure that you're working with a reputable title company, and I think you just brought that up. So happy homeowner just purchased a new home. He didn't realize that the beautiful, recently redone garage extended a foot into the property's easement, a long driveway that both he and his neighbor used to access their garage. The neighbor hadn't realized the intrusion either, that is until he tried to leave for a dirt biking trip with his wide toy box trailer and could no longer fit through the driveway. This was a problem, so he forced the removal of this garage, costing happy homeowner money that he wouldn't have had to spend had he procured title services. Many people are not aware of this, but easements are also recorded against the property and reflected on the title report. Have you encountered this one too?
Oh yeah, I bought a tax deed in Lake George, Florida, right across above Orlando, and a little crappy trailer-looking house. And when we got there, I bought it. When we got there, and the driveway went back, and there was a house behind that faced the cul-de-sac around the corner, but the garages faced my backyard. There was no way to get out these garage doors without going right across my yard. I'm thinking I'm going to put a toll gate up there. I mean, this guy's got to drive through my yard. I'm going to get a bucket ride. So I didn't really bother worrying about it for a while because we were just trying to sell the darn thing. Well, we ended up selling it about a year later, just a couple months ago. And the guy's all ready to close on the deal. And he says, wait a minute, there's an easement here. So the guy, and it wasn't on the title. It was hidden deep. And there was actually an easement for that guy to get out my driveway. But he said he'll take care of it, and that's all right, so.
The nastiest one I saw was a guy, he actually played it and won very well. The bank got destroyed. The guy had a house on, I believe it was about 57 acres. And he had a guest house, and when he refinanced his home, which was about 5,000 square feet, the easement for the septic lines was on the 52 acres, but because you could only get conventional financing for the home in 5 acres. So they did a survey, and they actually only encumbered the home in 5 acres. And then he let it go. He had a guest house on the 52 acres and basically wound up letting it go and having all of that paid for. And then the bank had a white elephant. The county would not let them. It's basically you have a shed, a 5,000 square foot shed.
I was going to say a property they have used.
It's a white elephant. They wouldn't let him turn on any utilities or anything because the sewage easement was on the 52 acres.
Well, heck, we had that house at
Guy Farrell Road. Did you see that listing?
No.
Chaz, some songwriter.
we had that house on Dog Creek. The only way to get to the house was over this little crappy bridge that, like, every owner would build their own bridge.
Yeah.
Little tiny creek. But the bridge was on the lady next door, which happened to be the mother of the lady, the kid that we just bought their house. He lost it in foreclosure. So we're going over the neighbor's house, which is the mother.
Yeah, the neighbor was the aunt.
Or the aunt, the mother lived somewhere on the other side. So she started yelling at us for using her bridge. But, you have to allow people to get on their property in some fashion. So.
Well, but we did have one. It was fortunately a situation where there's a qualified family member. It was land attached to land, but yet we could have potentially looked at spending $30,000 to build a bridge if this would have been forced into having to actually construct a driveway. They had perhaps an easement appurtenant, or it's hard to say. There was not a recorded easement. There was access to the road, which had to go across the stream, and they had been using the neighbor's driveway. And we bought it at auction, but we were able to avoid having to fix it.
We just sold it for a couple bucks cheaper.
Let me ask you this, though.
We got 8 of them. How many more you want?
Let me ask you this, though. As far as a property that, like is here in Nashville, East Nashville, and the fences have been up for 30 and 40 years.
Fences mean nothing.
So when that property, because a lot of them didn't do, they didn't stake the properties. So that land that they fenced in 30 years ago, doesn't that become the person's land?
No. People are constantly moving those stones that have been there since the 1800s, and they move over here, move over there. It means nothing. With today's GPS,
you can have a hard time with an adverse possession case.
You see that all the time, though, in the tax records where a building is actually over on the other property.
That's generally something that's going to be more accepted in rural areas where someone has been utilizing land for their purpose, whatever.
Yeah, their property line goes from the guy's tree to that rock over there to.
When you're encroaching in a city, if people start putting the stakes down, they could probably make your stuff down.
You should take us on tour.
I should. Well, funny thing that you guys are talking about rocks and moving fences, because that's actually the next thing I'm talking about. So boundary and survey disputes, because this is what happened when I lived in the Lake region of Indiana. So even if you've seen a survey prior to purchasing your property, there may be previous surveys that show different boundaries, and another party may be able to claim ownership. And my example is when I worked in the Lake region of Indiana, we had a property that had been passed from one family member to another family member throughout the years. Think old remodeled cottage lakefront. Legal description when we received the order was from Mary's fence to Jim's tree and so on. Because we needed a new legal description for the property, surveyor was hired. Legal description and survey proved that while the homeowners had thought that the lots were straight, they were indeed angled, and 6 foot of the front corner of the house actually resided on the neighbor's property, as did part of the driveway. Customers had to hire an attorney, draw up easement agreements for the driveway and part of the house that stated it ran with the land, so as long as the house was not torn down. If it was, the new structure had to be put on the correct property within, according to all the new guidelines, and the easement would be vacated. And I've also seen in these types of situations where neighbors have asked to be compensated, and you were just talking about that as well, for the use of their property. And my question was, have any of you encountered any of these issues? So.
Yeah, I can't remember actually dealing with having boundary issues preventing any kind of closings or anything like that. I mean, you certainly see little fences get moved here and there, but I don't think I've ever had a big.
I bought a house in Fort Myers that had 2 lots, but the house was, the 2-car garage was sort of 1 car, half of the garage was the middle property line. So I wanted to build a house on the second lot over there. So I was going to just rip off the whole garage and have no garage and have 10-foot easement on that side. And that's what I ended up not doing, but I talked another guy into it. I sold him the property. I told him that's what he got to do is just rip off the whole garage, and he has 10 foot aside and has a whole extra lot to build. So there's always a way.
Our last title issue is illegal deeds, which you've already touched on this too. Chain of title may appear correct and sound. However, if a prior deed was made by a minor, person of unsound mind, undocumented immigrant, or married person that claimed being single, this may affect enforceability of prior and present ownership. And we actually just had an issue recently. Again, Florida is a great fraud state. I had an investor that was interested in purchasing a property at sheriff's sale, contacted me on Wednesday, and the sale was going to be Thursday morning. He asked if we could run a quick title search on the property, and what we found was disturbing. When I contacted him back, we performed much more than a quick search. There have been 3 deeds that had been recorded against the property in the last 2 weeks, each one totaling greater than $200,000. Property transferred from an LLC to an incorporation and to another incorporation over the course of the last 2 weeks. We didn't find any common owners for the LLC or the incorporations, and clearly none of them had the right to transfer the property. And when the property was sold, these deeds would have created a cloud on title and thousands of dollars in fixes. How would you handle properties that
Investment group, was it?
That actually intrigues me just a little bit, because is there a possibility that investors are doing this to muck the things up, to take the deals down themselves? If there's that much,
it's highly possible. I mean, I've seen more things in Florida since I've gotten here than I've seen in the last 6 years.
Well, a lot of stuff we do that because code enforcement. Nobody does more quick claim deeds than I do down there. But I remember in 2009, July of 2009, they finally, I used to quick claim all the time, and you used to be able to just sign, I'll quick claim to you, whether you knew I even quick claimed it to you or not. I used to be able to go record it. Well, then I remember July 1st of 2009. I didn't find out this till like August. That the other person has to accept the quick claim, from one to the other. So there had to be another signature on there of the acceptee. Because I remember when I got divorced, I quick claimed my half of the property of our homesteaded house to my ex-wife. But I just did it and recorded it. Well, I get a letter back saying that it was invalid, that you're going to have to come in or redo it and have her sign the other side. I decided not to. To this day, I figured I got a little clout on it in case she marries some loser down there and he tries to take half the house. I can, mic up the deal and then, help out my ex-wife a little bit.
Let's go. I want to go back to your example for a second.
Sure. Sure.
Does not a sheriff's sale, and we don't deal with these in Tennessee, but when you get the sheriff's deed, is that not warrantable title? In other words, the sheriff is going, this is a judicial foreclosure. The judge has already put the hammer down, and normally when a judge says something, it straightens up the order of everything. That's kind of what they do. In other words, judge gives an order, this is happening. That all of the gobbledygook that happens after the judge's order really doesn't matter. Isn't that sort of irrelevant? I'm trying to understand this situation, or I know you may not know quite enough about it to get into it.
I was gonna, and to be honest, we looked at this when we talked to the investor about the deeds that had been recorded. They said, never mind, I don't want anything to do with it. It can create a cloud on the title, and it can have somebody have to do quiet title, which a lot of people don't want to have to do.
I buy tax deed auctions down there, and a lot of times I'll do a quiet title, take a couple, 3 months to get it. Sometimes I sell them before the 3 months and let them finish it up, and do a quiet title down there to get that warranty deed.
Because most companies don't really like special warranty deeds, or we definitely don't like kind of junk deeds, as you stated. Oh, sorry, it froze up there for a minute.
Your company do the quiet title, or
we hire that. I have an attorney that I work with here that does that.
Yeah, I got an attorney down in Sarasota that does that too.
Okay. So, this is just a little bit about the company. We were established in 1989 because we finished with the presentation part. We were established in 1989. We offer national strength. Our national services division actually can do title in all 50 states. And we have a local office experienced staff. We do have mobile notary services available, which actually is a really big deal here in Florida, not so much everywhere else. And we do have default and services and appraisal division. And then the last one is just kind of a fun slide here. It's asking you to like us on Facebook, just like the company. And do you have any questions that we haven't already discussed?
I think I'm good.
I have a question though, off topic. You smile. What are you smiling for? I haven't even asked the question yet.
I just smile.
All right.
Anticipation.
You mentioned, or I saw somewhere that you mentioned that you want to get your real estate license down there.
I almost have it.
Okay. Now let me ask you something. Or if you hang your license with a realtor down there, you're sort of favoring one realtor over another. Did you ever hear of EXP?
Yes, I have actually.
Oh, Mark just joined the EXP. We need to talk.
Well, yeah. I mean, see, that way you're not really tied into any one particular broker down there. Yeah. It might be a good thing for you to look into that.
Okay.
Because this way you're global, or you're at least national, and you're not really tied into one. Because then you would have to give when you're doing something, what do you call that, the disclosure that you're, with this one broker over here, that you can't do deals unless you disclose. That might be a good thing for you to look into, where you're sort of everybody's person as opposed to one person.
Let me do a shameless plug. I'm going to give a little bit of background here. I have been the top RE/MAX agent in Tennessee. So I've sold 300 houses in a year and made
congratulations.
I've made over $1 million in commissions multiple years. And I will attest to this. I have been a RE/MAX agent. I hold my license with a friend of mine. I've been a Keller Williams agent, and I hold my license with Exit with a friend of mine because I buy at auctions now. I can tell you without any hesitation in retrospect that there is absolutely no question that I would do this again through EXP. Having built things up the way I did, and just the number of connections that pass through what you're doing, I can vouch for that. Now I can't, obviously with Green we do education, but I'm going to go ahead and give these guys a shameless plug, because what we're doing with Green is we're trying to build networks, just like Mark said, bring people together, have mastermind discussions like that. So I'm in favor of recruiting models in real estate. I think they create this sort of incentive for people to come together and bring this kind of energy. But I'm just going to tell you from my experience, which is about the same lengthwise as yours, but actually as the agent, about 17 years, I would say wouldn't be a question. Starting again, if EXP were around, I'd gone straight there.
I'll give you another shameless plug. Just so happens that the years that he was the top seller, I got to Nashville and I bought 80 properties off him in the first month. But hey, he doesn't ever mention that part of it. But hey, I don't want to say anything.
Too funny. I did one other on here.
Say it again.
I said I did include one other piece on here. It's an attachment if you guys want to look at it. It's a title commitment.
Is it the bill? Oh, okay.
It's here. I just put together a title commitment. Clearly, you're very savvy, so you've seen these before. This is really, I use these when I train a lot of my agents to show them truly the effective date up here, that it's different than the actual closing date, that the owner's policy is different than the loan amount, who the proposed insureds are, both buyer and seller, and then basically the normal language. And then here, and I'll use the fancy tool that I haven't used yet here. We'll highlight in pretty blue. But here, oops, I didn't highlight and I didn't underline very well either. But we listed 3 mortgages on here just to kind of show what an example title commitment looks like, so that everybody can see some of the things that do show up and what to be looking for.
Who do you underwrite for?
Yeah, who do you underwrite for? Don't say Chicago.
No, not Chicago.
All right.
Old Republic and Fidelity.
Yeah, okay, that's good. Chicago, you'll be out. We just can't take Chicago. They're just terrible. I have never had a good experience doing a Chicago title. Listen, one of our big flippers who are up here, he flips 5, 6, 7 a month up here. Paul Kazanowski. He's down Southwest Florida. I know he's in Fort Myers, and we have one of our members has a title company there. But he's going to be all the way up the coast. I know he's looking up in St. Pete and Sarasota and all this stuff. So, that's what we try to do. Is I try to let's match our members up and let our other members reap the benefits of Green. That's what we try to do. So I'll make sure that Paul has your phone number. He usually comes, but and then of course we buy all the time down there too. So
I would love the opportunity to do that.
Yeah, you're all over the state, right?
Yes.
All right. Any other questions, guys?
I don't have any. No.
I do.
Great. Okay.
Oh wait, we have a question from our videographer, whatever you want to call him.
Videographer.
That's Marcus. Sit up.
I don't know if you can see my head.
Sit up there.
No, she can see me because I can see where I am. And I got to run back to back. So, quick question. What exactly is your job title?
Creator of all things, doer of all things.
I love that.
Technically, Director of Business Development, but I'm in charge of the state of Florida.
Okay. And you create title insurance, or you set it up? How does that work?
Marcus is new to real estate.
Brand new. So I missed stuff here.
He's learning a lot of stuff when he comes here.
Absolutely. Perfect. So what I do is I'm the person that you see in the front, and I take the order and work with the realtors and work with the lenders to get everything prepared. We do the title search. My staff does the title search. We prepare the title commitment, clear the title commitment, and then we do the closing, and then we issue the policy afterwards.
Yeah, how long does that process usually take?
Depends on if it's a cash deal or if it's a purchase with a loan. Often we can do a cash deal in 5 to 7 days, and it depends on if the property has an HOA associated with it. They can take a little longer because sometimes they don't play nice with us. One with a loan, most lenders are going to tell you somewhere between 25 and 45 days, depending on their process.
How many offices do you have?
Here in Florida, we just have one.
Okay.
But across, we have a national services division that's actually out of Kansas City, and they actually facilitate transactions all across the United States. And then we have multiple state offices. We call them state offices when there's an actual physical location someplace.
Not the actual. Are you actually in the closings? Are you coordinating any of the transaction process, or are you on the marketing / managerial side of everything?
I do both. So I work with my customers. If my customer wants me to show up at the closing table because they're actually come to the closing table, I'll be there. But in a lot of our cases, kind of like we're doing this right here, we do a lot of things. I've done closings via Skype. We just have to have a notary someplace, wherever they're going to be signing at, to notarize a few documents. So we email a lot of our documents out. So I'm trying to help Marcus with this line of questioning, because it's a picture of business being owned by somebody. You're not the owner of the business, but the business has created an incentive for you to boost the volume of business and given you some overall managerial responsibility, which means you do whatever needs to get done to get stuff closed from time to time. But ideally, they want you out there building relationships and getting real estate agencies, brokerages, anybody that's going to bring in 20, 30, 40, 50 deals a month. So her position is it's more related to how their individual business is structured, as opposed to it actually being a necessity for every business, if you see what I mean. In other words, the owner of that business basically gives her a greater incentive, and there's good money to be made.
She's the cute blonde that they send out with all the pens and the papers and all that books and stuff.
Right,
they can go around all the mortgage company. I know, well, I get all my pens from you guys.
But I actually have a brain too.
Well, all right, well, that's why you get the big bucks.
Right.
You're in Florida, right?
Correct.
Okay, so if we had something that was going up here, do you have like jurisdiction just in Florida, or can you do work for us up here in Tennessee?
Do you have anybody here?
We have an office in Tennessee, and we can do work in Tennessee. Yes.
Where's your office here?
I would actually have to look it up. I don't know where all of our branches are located at.
Memphis, Nashville.
Let me look.
All right.
I'm good. Thank you very much.
Thank you, Trisha.
Thank you. Thank you, Trisha.
All right, go finish it.